Before this court will draw near to the attendance and they shall be heard.
Is the door locked? Okay. Quickly, we have. Oh, still, it doesn't matter because
It's submitted? Okay. Oh, all right. Wow.
It's first time for this. You had this before?
I've never seen this before. Oh, be careful. Don't touch my phone. There was a reason for that.
I'm guessing there was.
Boy, I thought, what a day this is going to be. Were you guys getting nervous? Or were you happy? Okay. First case for oral argument this morning is 179, People versus Luciana Pine Perilla. Good morning, Mr. Keem.
Good morning. May it please the court. My name is Brad Keene and I represent the defendant appellant in this matter. Let me start with the emergency exception.
Wait, I can't hear you. You gotta, how's your speaker? Where is your speaker? Try it again.
Are you able to hear me now?
Yes.
Okay. We assert that the emergency exception did not apply here. There was simply no emergency in the case at bar. This court recently decided People v. Lee, which we assert is analogous to this case. At the time the officers entered appellant's residence, appellant was secured. The officer testified they had no knowledge of anyone else in the residence.
Okay, well, let me ask you, does it, in the end of the day, does it matter? Because they
Additionally, the
didn't,
mere presence of narcotics.
what's going on here? You can't see this, Mr. Keem, it's weird, the way this is going on. But at the end of the day, does it matter?
So I assume that you're saying that because of the warrant, it would have been inevitable to have the drugs?
Yes.
Okay. So to address that, I think that this court has the power to, assert that the officer testimony was not credible. You had a man in the room who heard the officers searching. He heard bangs. He heard bingo when supposedly narcotics were found. I think the photographs support that assertion. The narcotics were allegedly discovered in 3 minutes. Barr also entered that residence before he got the search warrant. And I think that is also a strong factor in finding
Okay,
a
we'll
lack
look
of
at that
credibility by the officers.
We'll look at that very carefully.
But was there a notice of
Okay,
appeal
unless
from
there
the
are questions on
judgment
our
of
other issues.
conviction? Was there a notice of appeal from the judgment of conviction? Did you file a notice of appeal from the judgment of conviction? I know there was a notice of appeal from the resentence, but what about the judgment itself, the judgment of conviction? Did you file a notice of appeal?
So there was a sentencing issue, and then there was a notice of appeal to, I believe the notice of appeal covered the judgment of conviction and then the resentencing.
I'm not so sure of that. But we'll look into it.
So, okay. I understand that I'm not permitted to ask the court questions, but is there any other questions about the notice of appeal that I could potentially answer?
I don't think so. Thank
All
you.
right.
Morning, Your Honors. I'll
I'm
start.
sure that's the first thing you're going to bring up.
I was going to say, honestly, I would have to look at the appendix or the record because I don't have particular recollection at this point in time what the nature of the notice of appeal was. I think I perhaps mistakenly just sort of operate under the assumption that they are filed in the normal course of business and they cover the
Well, we'll look
matter.
into, we're going to look into that issue.
If I think our brief lays out our position on the circumstances of the entry, but I'll answer any questions if there are any.
Thank you. 182, People versus Mitchell.
Good morning. May it please the Court. Mr. Mitchell urges that the failure to timely provide criminal history information as to the complainant as required by CPL 24521P was the result of the Ontario County District Attorney's not making reasonable inquiries or exercising due diligence. First of all,
Well, they didn't make any inquiries, did they?
they made no inquiries of their own files. This office...
Well, even the sheriff's department, they didn't request that. That came way, like, months before the indictment, correct?
The sheriff's report, which was not a DCGS report, was dated January 21st of 2021. He was arrested on August 4th, 7 months later, and the certificate of compliance was 9 months later. And there was no allegation of any inquiries in between for the complainant's
So there's no
criminal record.
evidence whatsoever that the DA in any way requested any information regarding this victim.
That's correct, and what's critical, I know the Court's aware of that, is that the Supreme Court in Giglio and the Court of Appeals in Stedman held there's a constitutional duty for trial DAs to provide criminal history information possessed by their office, as to even if that trial DA is unaware of it. In this Court, in Bibb v. Valentin, Bibb v. Presley, has held as a Brady violation to not do so, even when the trial DA was unaware. It's important to note in Giglio, which is
Well, in
1970...
this case, I mean, you can go further. In this case, not only were they, how can I put this? They should definitely have been aware because the conviction came from that court.
That's correct. And the DA who actually obtained it was still an assistant DA in that office. That's all correct. The Giglio decision, which again in 1972, states that DA offices need to develop procedures to ensure that their trial assistants have access to and are aware of the information possessed by others in the office. So this isn't like a new rule. And our argument is a simple one, which is the failure to do what is constitutionally required is not a reasonable inquiry.
Now, let me ask you this question. What do you think the remedy is here?
The remedy is dismissal. And People v. Bay, the Court made clear, but the statute says if there's a 30-30 violation, in this case there was, because there was not a valid certificate of compliance within the statutory time, the remedy is dismissal.
Did the judge below make that determination? The calculation of the...
No, and one of the reasons there's no calculation made, and this is important because the district attorney in their brief urges if there's to be a reversal, it should be remitted for consideration as to whether it's excludable time. The district attorney and the court below, neither in their response to the motion and papers or during oral argument, ever argued there was any excludable time. In People v. Santos...
Let me ask you this question. While this case was down below, wasn't there a concession by the people that 30-30, that they'd messed up? Right?
Well, yes and no. It initially appeared they said that, then they tried to say, well, it's excusable because we relied on this report from the sheriff, which again, as you noted, was way before the arrest. There's not a DCGS-based report, and it's from the sheriff who the DA told the court that until September 29th of that year, which was...
They weren't cooperating.
They were not cooperating. They weren't providing discovery. So we argued that there was failure to exercise reasonable inquiry or due diligence. The Court of Appeals in Santos held that when there's not a factual issue raised below as to excludable time, the court can't remit. for a hearing on that. They don't get two bites of the apple. The time for the district attorney to urge that, well, if we lose on a 30-30, on the issue of due diligence, is still excludable time. They can't do it for the first time on appeal to this court. The time to preserve that issue is in response to the motion. They didn't do that. And that, again, Santos...
Well, you seem to be arguing it both ways, though. You said that they didn't raise it at first, then they tried to, so
No.
did they or didn't they?
No, they didn't raise excludable time. They argued that there was due diligence. They didn't concede that. If I misspoke, I want to be clear about this. They argued that there was not a 30-30 violation because there wasn't they argued there wasn't a 245 violation. But they never, ever, in papers or in court, said that there's excludable time. And if you don't argue excludable time at trial court, you can't get a remit to argue that. I think I need to cover 1.1. I'm sorry. You had a
Oh, no,
question?
I was going to say, I think we have your argument.
Yeah, on point two, it's our contention that when Mr. Mitchell, after trial, where he was acquitted of the top 3 counts, the 2 rape counts and the kidnapping count, when he was sentenced to more than 3 times longer than what the plea offer was, when he was facing those counts, when no new facts were developed at trial, or alleged to have been developed at trial, when the trial court had indicated that the original plea offer was acceptable if Mr. Mitchell agreed to waive his right to appeal the 30-30 issue, that under those circumstances, the imposition of that sentence was harsh and excessive. The court, in justifying that sentence, the way we said, we don't compare the charges, the court said you compare the charges that he was offered to plead to versus what he was convicted of. But the comparison that this court has used over and over again and other courts is what charges he was facing before trial and after.
You know we know it.
Thank you, Your Honor. I appreciate it.
Thank you. My very first question.
I know, I have a feeling. So I would push back on there being no inquiries here. So there was the comprehensive report that the district attorney asked be issued in this case. As far as
District attorney never asked that they be issued for this case. What they received from the sheriff's department was before this case was around.
it was before the case had been indicted, but certainly there
Right.
was ongoing investigation regarding this case because it was a years-long incidents that occurred over a domestic violence relationship. There was certainly quite a bit of investigation that went into this case.
And again, though, this is from their own office.
I would ask that, though, that the court not keep that as the standard. Certainly,
I'm not keeping it a standard, but it goes into the calculation.
Well, so Bay does give us the, how likely is it that the prosecutor might have overlooked this particular information. Certainly her conviction was out of the Ontario County District Attorney's Office. It happened back in 2015. And even with a smaller county, we're still prosecuting several thousand cases every year. So certainly when you're looking at then the bigger counties, being able to recognize that.
But as a prosecutor, don't you ask your witness, whether you're a prosecutor or a defense counsel, don't you ask your witness, if you plan to put them on the witness stand and she was your star witness, don't you ask them, have you ever been convicted of a crime? And if so, what was it? Just as a matter of practice for a witness that you're going to put on the stand and subject to cross-examination.
Certainly, you would want to know that information. Absolutely. I would not push back on that at all. But the district attorney had no reason to look beyond the comprehensive report that they had, which indicated a number of personal factors about this particular witness, this victim here, and it's indicating no criminal history. So it's...
Yeah, but the legislation doesn't exempt small counties because the county legislature doesn't want to fund the DA's office.
Certainly not.
And I still don't understand how you justify not knowing the DA's office's own record of convictions. I mean, it's one thing to blame the sheriff's department and say, oh, they're being uncooperative, which is another, because the statute doesn't recognize that. The statute says you supervise the sheriff's office as a DA in terms of the discovery demand. But in terms of how do you not know what your own office, and how do you say, you said to Justice Smith originally that I hope you don't hold that as a standard. I don't know what you meant by that.
Just that even with a smaller county, you're still prosecuting several thousand cases every year. So when you look at the bigger counties, whether the DA's office is pulling those records and based on just a familiarity with this particular witness, the question really that we're urging this court to consider is what is reasonable. So the prosecutor here had a report that indicated no criminal history.
We
Is
understand
it
that.
reasonable to rely on that? Or whether they needed to run
Right, and
additional...
we understand that. That's what we have to decide, whether that was
Ms. Porter?
reasonable.
I'm sorry, Robert.
Oh, I was going to go on. I was going to ask you about the concession here.
So there is one line in a motion that was
Right,
filed.
and it was on the supplemental affirmation, 9/9/2022, conceded that the 30/30 time had expired. It was said, it's conceded after conducting an analysis that the CPL 30/30 timeframe had expired.
Certainly more than 6 months have passed. So as we noted...
This is the language that
Right.
was in the affidavit, the affirmation.
Yes.
They're conceding.
That certainly the 6 months had passed, but we never got to the point of any sort of a calculation on excludable time. The court never issued a ruling with respect to 30/30. So, and because their 30/30 argument depended on the COC being declared illusory, we simply never got to that point because the court found the COC valid. So that the district attorney had exercised due diligence and made reasonable inquiries. And getting back to your point, Justice Ogden, on why would you not ask a witness that, our point is that the district attorney had no reason to do that because they were relying on this information that had come through this report. It certainly came up in trial preparation when the witness then corrected and said, oh, no, I do have a criminal history. And then if you look at the steps and the extremely expedited timeline that the district attorney then acted to get those records, to provide those records to defense counsel, who received a remedy from the court then and getting an additional several months to prepare for trial. So the court did look at this under whether the COC was illusory, found due diligence in that regard, and then moved on to 24580 sanctions and remedies, did grant the remedy in that regard.
Ms. Porter, the guiding principle at this point is from the Court of Appeals in Bay, correct?
Yes.
And there they listed a number of non-exclusive factors in Bay, right?
Yes.
And looking at them, as the Court of Appeals stated, the first one was the efforts by the prosecution and prosecutor's office to comply with the statutory requirements. That strikes me as sort of a holistic assessment of the overall performance by the DA's office in connection with compliance with the new statute, or somewhat new statute. And as I understand it, in your certificate of compliance, which is about 12 pages long, you produced the cell phone forensic reports, the interview of the defendant that was recorded, the search warrant application, the search warrant, the grand jury testimony. I think there's a lot in here, so should we look at this in terms of what else did the prosecutor do? Is that part of our analysis under Bay?
Bay specifically directs that. So it is, as you mentioned, Justice Curran, it is a holistic look. And the COC that was filed in this page has pages and pages of attachments with single line items that were disclosed prior to this. So in terms of
But your Brady obligation exceeds even the COC requirement. You have a Brady obligation to turn that information over, wouldn't you?
If we're looking at it under Brady, which isn't necessarily raised here, the prosecutor would have to be suppressing that information. And that does depend then on the prosecutor's knowledge, which if they're relying on this comprehensive report, I don't think that would fall under Brady at this point because we're not meeting that particular prong of Brady. But under a discovery standpoint, there's no question that this is discoverable information. I don't think that that's ever contested at any point. It's just the prosecutor's due diligence in filing their original COC and then the actions that were taken after this discovery violation came to light. And
the attachment to the COC, the 12 pages or so, whatever, it has a list of everything that's produced. As I understand it, most DA's office in today's day and age are putting that information on an electronic or digital portal. So all the photographs that were taken by the victim, they were posted within 30 days of the indictment. Cell phone records, everything else I told you before, the forensic reports of all 3 cell phones that they looked at, that was all produced in addition to the other items I'm probably forgetting, but that list that's there, that corresponds to what was produced in the digital format or digital portal, correct?
Yes.
Okay. So then we go to the second Bay factor, which has to do with the volume provided and outstanding. The volume provided that you gave was huge compared to what was still outstanding, correct?
Correct.
Then it's the complexity of the case. Here we have allegations of rape and assault that date back to 2017 largely, and then 2018 somewhat. And the report of abuse is not until December of 2020.
Correct.
So in terms of retrieving all this information that primarily comes from the victim, that's the context that we have too in terms of the complexity of the case. I'm not sure it's terribly complex, but there's some complexity given the time frame. Do I have that right?
I would certainly say so. This is a years-long relationship between the two, and you have the fact of a delayed report as well. So you're going back over the past several years trying to collect as much evidence as you can and turn that over in a timely fashion, which certainly was done. The only issue in this case was that the prosecutor relied on a report that was inaccurate. So
I think we have that argument.
And then the another factor is the explanation for the discovery lapse. Here the explanation was, hey, we had this information before, now we understand what you're looking for. There probably should have been more by the DA's office, as a number of the members of the panel have done. And then the last factor is what the prosecutor's response was when apprised of the missing evidence. And it was immediate here, correct?
it was within, well, there was an email sent, I believe that same day that it was figured out, and then the county website was down, but the information was all turned over within 2 days, and the supplemental COC was filed. So certainly the actions that were taken in response. Right.
But you still had a requirement for due diligence, and due diligence would have required you to seek a nice criminal history on your star witness, regardless.
So our position is that the prosecutor did do that, simply that the information was inaccurate. And
I think we have that argument. Is there anything further?
Unless the court has any additional questions, I'll rest on my papers. Thank you.
184, People versus Smith. Oh, I'm sorry, I'm looking. Good morning, can you unmute yourself, please? Thank you very much. Go ahead.
Okay, good morning. I'm Dave Pajak. I represent Mr. Smith on this appeal. What stands out to me in this case is that the prosecution obtained 5 convictions for essentially what was one single crime. Starting out with the victim's testimony, she states that she was awakened in the middle of the night. She was naked. The defendant was touching her and licking her all over her body. Now, this is one continuous assault. It's not like he touched her in one spot, left to get a sandwich, came back and touched her and did something else, and then she went to take a bath with the cat.
Okay, we understand that.
But Counselor, isn't it long recognized that in sexual abuse cases, when there's different types of acts, that they can be charged separately?
If they're separate acts, but this was a continuous assault, and that's the Alonzo case.
You term it an assault, but it was different act, because, I mean, if we got very specific, you're talking about forced, penal to mouth, and then there's touching and different private parts, so those are considered separate acts. And the prosecutor is right to charge separately for that.
Well, it's a little more complicated than that, because in this case, you've got 2 charges of sexual abuse in the first degree, which is any sexual contact with a child under the age of 11. Now, when you have a child under the age of 11, how do you also not commit sex act in the first degree, which is any oral or anal contact with a child under the age of 13? You can't violate Sex Abuse 1 without also violating Sex Act 1. You have 2 different sections that under which the same conduct is illegal. So they're multiplicitous counts to begin with, but yet they're all charged separately. And he's got 5 counts for what was essentially one continuous assault. I'm relying on People versus Alonzo, which I have in my brief. And I'm sure you're familiar with it.
Right, and what we're gonna have to do is we have to look through it and go through this, which we have already done, and we will do it again to determine whether or not this is one continuous act or not.
Okay. The other thing is, not to beat a dead horse, but I've got to look at counsel's conduct in this case. Why would you not make a motion to dismiss the multiplicitous counts? Why would you expose your client to 72 years of prison time? Why would you not move to dismiss them? Some or all.
Okay, we'll look at that.
Yeah. Oh, okay. Let's see.
Why don't you go on to your harsh and excessive?
Yeah. Yeah. The other thing is the story here of the complaining witnesses. Is that believable? I mean, Mom's a career forger, a liar. She's a drug addict. Kiana, the victim, has repeatedly lied to protect her mom and to keep the family together. Mom's broke and desperate. And as defense counsel explained, and I agreed with him, the only reasonable explanation here is that Mom sold sex in return for the drugs. Where else?
We'll look at that very carefully.
Okay, thank you.
Thank you.
Good morning. It's people's position Alonzo is very distinguishable from the facts before this court. Alonzo, the actions were so vague that the victims couldn't even tell how many times they were being touched and specifically where they were being touched. I think the Court of Appeals says it's completely unreasonable to hold the defendant for each alleged act when the victims can't even delineate. That is completely the opposite here. And I won't go through the conduct alleged, but I think on page 175 of the record on appeal, in the people's response to the bill of particulars, we very, clearly articulate the specific conduct that's alleged for each count. And they are distinct acts and they are distinct crimes. And I believe it falls squarely under this court's decision in Boyd and the indictment was not multiplicitous. I go into great detail about the victim's testimony and the strength of the people's case. It is our position that the victim was entirely consistent. She's corroborated by DNA evidence, and we ask that this conviction be affirmed.
185, People versus Blake.
Good morning, Your Honors. Kathy Reardon for Camus Blake. Excuse me. Under points 2 and 3, we're seeking a remittal to the trial court or an adjudication of youthful offender by this court. We'll rely on our brief for those arguments. Excuse me. In the alternative, we'd submit the waiver of appeal is invalid. We're asking this court to consider reducing Mr. Blake's sentencing. He was a 16-year-old at the time of the first incident, 17 at the time of the second incident, and had no prior convictions, no priors at all. He was sentenced to the high end of the sentencing. It was 3.5 to 15. He got 12. The individual, the co-defendant technically, who actually fired the shot that injured the police officer, got 16, so he only got 4 more years than Mr. Blake did. He acknowledged that he had made some really bad choices. He was apologetic to the people that could have been injured, to his parents. He had really good family support. His mother was there constantly. He was cooperative during the investigation. As soon as they found the gun in the second incident, he basically handed it over and acknowledged that it was his. He cooperated with probation and with the court. As a result, we're requesting that this court consider reducing his sentence as a matter of discretion in the interest of justice.
Thank you.
Good morning, Your Honors. Lisa Gray for the People. With respect to the waiver of appeal, the people did concede in our brief that under Thomas, the waiver in this particular case is invalid. And I will rest on my brief with respect to the youthful offender adjudication and move on to the harsh and excessive issue. In all respects, this particular sentence was reasonable under the circumstances. These were 2 separate indictments. Mr. Blake received a 12-year determinate sentence for the attempted assault in the first degree, which satisfied, I believe, multiple other violent felony offense counts as contained therein. And indeed, although not I don't think particularly raised in my response. Mr. Blake could have received consecutive sentencing, and he did not. This was a concurrent sentence. So although for a 17-year-old, a 12-year-old term of incarceration is considerable, it was appropriate in this instance. I mean, the court, I think, really articulated the facts it was taking into consideration when imposing the agreed upon sentence, and certainly I think the court really had a problem with a lot of the boastful social media postings Mr. Blake engaged in with respect to displaying these weapons, boasting about firearms possessions, certainly in a city that is just plagued by gun violence. So for all those reasons, the people would ask this court to affirm Mr. Blake's conviction in its entirety. Thank you.
187 in the matter of Gabriel H.
Good morning, Your Honors. Nicholas
Oh,
Texedo.
wait just a minute, we have to wait.
I'm sorry, Judge.
We have to unmute you. And we just need, there we go. And can you unmute yourself, please? Thank you.
Yes, good morning, Your Honor.
Okay, go ahead.
Thank you, Your Honor. Nicholas Texedo for appellant Daniel K. in this matter. Your Honors, unless the court leads me elsewhere, I'm going to speak about simply the order of protection in favor of Gabriel that was issued. It's our position that under Khadija AA, that order would have been inappropriate in the first instance because there was no evidence that that Gabriel witnessed any abuse, that he was affected by any abuse, that the respondent below, appellant here, that he even had any interest in male individuals. There was no indication that Gabriel H. needed to be protected from the appellant. Now, even if the court properly issued that order under a derivative abuse theory, it was improper to include a stay-away provision from Michaela until her 22nd birthday under the guise of Gabriel's order. It struck me as a bit of a reverse engineering of a result here.
Counselor, what about the fact that Gabriel was seen in the video shortly before the incident occurred? What's your response to that?
It establishes that he was in the house, Your Honor. Not that he witnessed anything. He isn't in the room when any of the abuse is occurring. And he actually indicated during his interview that he had no idea and his sister had never confided in him about anything. So there's really no indication that he had any awareness of it whatsoever. But again, even if he did, the inclusion of a stay away from Michaela provision on his order of protection, it was simply, and I can see why the court wanted to get to that result, but we have to follow the procedures in the statute, and we can't reverse engineer the result we want and then work the law to get to it. The law needed to be followed. And you know, if the court finds valid the finding that Michaela was abused, sure, an order until her 18th birthday was definitely appropriate. But extending that to after her 22nd birthday by saying that for her brother's protection, the appellant has to stay away from her, it's a bridge too far, Your Honors. Thank you.
Go ahead.
Good morning. On behalf of the Erie County Department of Social Services, Benjamin E. Mannion. Your Honors, unless there are any questions from the court, I would merely reiterate that there was more than sufficient evidence presented through the form of the agent as well as the investigator from the state troopers that there were noises heard throughout the house. You know, he could hear everything from the living room, which was the site of the abuse. He heard his agents going around the house conducting their investigation at the time. It was reasonable for the court to infer that based on what was seen in the video and the fact that Gabriel was present at the time, that he would have heard the abuse even if he was not present to observe it personally. Moreover, appellant's contention that the order was inappropriate because Gabriel could not be affected because he was not the target gender of appellant's desires or appellant's actions is wildly inappropriate. There have been numerous studies that show that even just observing that type of behavior whatsoever has a negative impact on, even on any child, even if they are not the targeted gender. So I'd ask the court to disregard that argument, or at the very least pay it very little weight. And pending on any other questions, the department rests on to.
Counselor, can I ask you one question? On the sufficiency of the authentication of the video in terms of the state police testifying whether or not the video had been tampered with or not, and whether that part of the authentication was specific enough.
So I believe the FBI agent testified to the fact that he had a background in forensic or working with video in a forensic capacity. He identified that the video that he had seen, which was not tampered with by the FBI, that's how they recovered it, was how it was presented at trial. He testified that there were no indications of tampering whatsoever, and appellant raised no issues. They were given the opportunity to do so. They did not present any evidence at trial illustrating that it had been tampered with. So at this point, as it's before the court, it is just merely speculation.
But didn't the incident occur 3 years before the FBI even received the video?
Your Honor, that is correct. The timestamp on the video was from a date that was prior. However, again, as the evidence, that would go to weight of the evidence at this point, not merely the authentication of it. And again, considering that appellant did not testify at trial and was given warnings that if he did not testify, the court would take the strongest possible inference from the evidence, the court correctly arrived at the conclusion that the evidence was sufficient.
So your position would be that they essentially waived this argument, or they didn't preserve it, because if it was a foundational aspect that should have been raised at the time of the trial, they didn't preserve it for the appeal before this court. Is that what you're saying?
That is my initial position. That's the department's initial position, Your Honor. That is correct. And then even if the preservation argument is found to be preserved, moving forward, the department did present sufficient evidence. I believe that there was a statement that was relayed by the investigator in which the co-respondent mother in this case identified the appellant in this matter and her daughter in the video that depicted the abuse.
Thank you.
Thank you very much.
Go ahead.
Oh, thank you. Dave Jack once again for Gabriel Horder. I have a correction to my brief. I think I forgot to mention that the order of protection in favor of Gabriel directs the stepfather to stay away from him until his 18th birthday. That's a glaring omission on my part, and I apologize for it. I did mention that Michaela's order of protection is in effect until her 22nd or 20th birthday. Gabriel maintains he knew absolutely nothing about what transpired years ago. It had no effect on him. He's never had any fear of the stepfather. He wishes to be reunited with his mother, and he doesn't want anything to get in the way of that. And he would oppose the order of protection that's in effect right now, and also opposes the finding of derivative neglect in this case.
Thank you.
Thank you.
188 in the matter of Noah C. Morning. This is going to take a little while because we got.
Oh, sure.
By that I meant we have some video. Okay. I probably could have explained that.
Okay.
We need, let's see, 1, 2, 3 more people, right? There's one. Okay. two more. Do we have any update on this?
Sharon Allen should be coming right over, Judge.
Okay. And what about, who are we missing then? Oh, then I guess we're set, right? Okay. Sorry, just a moment.
Is Michael Pulver supposed to be here? He's on the top.
Oh, good point. That's a very good point.
That's all our remote parties, Judge.
Okay, great. Okay, go ahead.
Oh, good morning, may it please the court. I'm Michael Pulver. I represent respondent mother Jacqueline C. The first thing I want to say as a preliminary matter is that she's left respondent Greg C. and is divorcing him. Those papers are being prepared as we speak. She's left the home. The other thing is I want to address the allegation in the county's brief that my client said admitted to using drugs during the booking session. That was in there. 4 things. First, she denies it. Second, it's hearsay, which is obvious. Third, we have no way of defending against it absent an adversarial proceeding, which we don't have. And also, even if she did relapse, I think any experienced substance abuse counsel will tell you that relapse is often part of the recovery process. And as to my main arguments, I just wanted to point out that the mother has come a long ways in her drug rehabilitation. I represented her in her neglect appeal in 2021, and the court affirmed, pointing to her severe drug use. There were allegations in that record that she was so addicted that she ran out of veins to inject herself with drugs. That's a long ways from coming 2 years later, making it through inpatient onto outpatient. And the other thing is, with respect to visitation, the best I can tell, she didn't miss any visitation after the suspended judgment went into effect. She had a warm and loving relationship with each of the kids, and they reciprocated, and she tailored her warmth to the kids on an individual basis, according to their needs. That's it.
Thank you very much. Smallman?
Good morning, Your Honors. May it please the court, Carol Waldman representing the father. Practically, these appeals must be remitted to family court for another dispositional hearing. As my colleagues will argue, under Michael B., the circumstances with the children changed drastically while these appeals were pending. If the court decides not to remit these appeals to family court, the father respectfully requests that the court extend the suspended judgment for 1 additional year because my client was able to show exceptional circumstances, at the very least based on the fact that he was released from jail in July 2021. Even if my client violated the terms of the suspended judgment, it is not in the best interest of the children to terminate his parental rights. The parents had a strong bond with the children. The children were adamant that they wanted to live with the parents. The parents' behavior was appropriate during visits, and the violations of the suspended judgment did not affect the quality of the visitations. Unless the panel has any questions for me, I rest on my brief.
Thank you. Mr. McBride?
Good morning,
It looks like it's your turn, right?
Okay.
Go ahead.
Thank you, Your Honors. It's nice meeting you. Judge, the record was very clear, trial court, with regards to what was in the children's best interests. Certainly, this is a case where the parents were afforded multiple opportunities to overcome quite not only acute but long-standing issues with regard to mental health, drug addiction, and I believe that the evidence that was presented at the hearing showed that the parents continued to manipulate, most importantly, their children. So there was a reference made to There was a strong bond between the parents and the children. I think that that was negatively impacted and/or cajoled by the parents as evidence that they were clandestinely reaching out to the children, manipulating them in their foster home, in school, testifying in court proceedings. Also, I'd like to respond to the issue of remittal. Your Honors, this case is still pending in Ontario County Family Court. These children were freed, so this court, the trial court, is in the best position. They are continuing to work on permanency for the children. The two youngest children are still in the same adoptive resource. They're doing extremely well.
But doesn't the child run away?
That is the oldest child.
Well, we don't even know where the oldest child is.
Okay. The oldest child, yes, it had some contact with the parents. Our last information was that the oldest child was residing with the parents. As a result, he was physically assaulted. The father is currently incarcerated for assaulting that child with a flashlight, threatening to kill him, threatening to kill the mother. He attacked the mother.
We understand all that.
Counselor, though, isn't Jaden, he's 14 years old, he has to consent to the adoption, and the adoptive parents said that they didn't want to adopt him if he did not want to be adopted.
Yes, that is correct, Your Honor. The child, at the time of the proceedings, was hesitant towards being adopted. The child, however, is still there, and the child is doing extremely well in school and with services. The child has not run away. The second oldest child currently resides with the grandmother. That was his choice. And certainly, this court's familiar with the department's responsibility to seek out familial resources, and in this case, they did with the grandmother.
We understand that.
Thank you, Your Honor.
Go ahead, you have to unmute yourself, though. Ms. Barnett, you need to unmute yourself.
Good morning. Thank you, Your Honors. Mary Beth Barnett submitted a brief on behalf of child 4, that is the 15-year-old who now resides with his grandmother because he ran away to his grandmother's. I submitted a letter on behalf of the 17-year-old who I could not locate. I last heard about him third hand from the grandmother about a month ago, who said he had no place to live and he was on the streets, and called me in a panic wanting to get him into some kind of a care home. And on just, I've heard just, I don't have any direct knowledge that he may now be living with the grandmother, at least on a temporary basis, but I don't know the truth of that, in fact. So for these boys, this termination of parental rights did not provide any permanency for them. The plan put in place by the department just simply faltered. And
so you'd like this be remitted and figured out again?
That's correct.
Okay,
and
thank you.
Okay, thank you.
Who's next? Oh, Mr. Marvino.
Good morning. I represent Jacob Castellano, the youngest of the children. He has, throughout the entirety of these proceedings, lived with the Bumps, the foster parents. He is doing exceptionally well there. The number of times I've met with him, he's swayed between wanting to be adopted to wanting to have meaningful conversations with the foster parents about being adopted. However, with the pendency of these proceedings, obviously all of that is on hold. I think it is my client's best interest to affirm the lower court's decision related to Jacob and allow him the opportunity to proceed forward with adoption if that is something that he wishes.
Thank you.
Thank you.
Ms. Allen?
Good morning, Your Honors. If it pleases the court, I am Sharon Allen. I represent the child Jaden C., who is 13, will be 14 in November. Your Honors, I will rest on my papers as to the substantive violations of the parents, except to say that as to the mother, I believe that the nature of the violations were not violations that had any impact or nexus to her ability at that time to provide a safe home for the children. I believe the evidence did establish that enough information was able to be gleaned from all of the sources and services that the mother was involved with to know how she was doing, and that really she was doing very well at that time. Obviously, a large amount of time has passed. We don't have information, or I don't have information about how she is doing now. But my client's position continues to be that his ultimate goal would be to be reunited with his mother. I think that is where the court erred here, is not giving enough weight to the bond that my client has with his parents, with his desire to be with family. I think the last minute position of the foster parents to be an adoptive resource, I think that seemed like a really great thing at the time. But it did not take into consideration the fact that my client does not want to be adopted. He did not want to be adopted then. He does not want to be adopted now. And I think we can see from what has happened since the court made its decision that this decision was not in my client's best interest. The result is he went from having regular contact with all of his brothers to only being in a foster home with one of his brothers, to at the time I wrote my brief, not knowing really where his older brother was, having agency supervised contact once a month with his brother Romeo. It's my understanding since I wrote my brief that Noah has surfaced, that he is residing with the paternal grandmother now, and as of right now, my client is having agency supervised contact with Noah approximately 2 times per month. But this is obviously still not nearly sufficient for my client. How the mother was doing, my client had the opportunity to potentially have a home with all of his family, certainly his mom and his brothers. And I think the court's termination of his parents' rights, especially in light of how...
So how do you feel about this being remitted?
But Judge, I believe that it needs to be remitted, given the fact that we just don't know everything about how everyone's doing right now. But I definitely believe it needs to be remitted.
Thank you. 189, Burke MD versus Kaleida Health. Good morning.
Good morning, Your Honors. May it please the court. I'd like to just start with the law, because I don't know if you agree with me, but I think the legal questions involving the common law questions and the statutory questions are all related. The statute, the New York 2805M, says there's no protection and there's no immunity if the communications are untrue and communicating with malicious intent. The federal statute uses similar language, and the common law rules pretty much use the same language. So I think the question is, did we produce evidence that a reasonable jury could conclude that there was legal malice here, actual malice? We think we proffered enough evidence to show both. I think the court may have gotten lost with Dr. Grandy. Dr. Grandy was the chief of anesthesia for Kaleida. And until he got that position, he was not in a position to hurt my client like he did. And it's the combination of having that power at Kaleida and also having the influence in the group that doomed my client and virtually destroyed his career, but for Judge Franzik stepping up and annulling the suspension. So there's no discussion of that in the decision. There's no mention of either Judge Franzik's decision. There's no mention of the finding in the arbitration that Dr. Grandy acted in bad faith. and did not do a good faith investigation to investigate the facts before issuing this summary that Kaleida then wholly adopted word for word as their preliminary suspension. Add to that the conflict that was present for Dr. Gibbons, whose partner, he was the admitting physician for the patient that led to this problem. His partner was the surgeon on the case. He never signed off. Neither Dr. Prosky nor Dr. Gibbons signed off. Kaleida says you don't have to sign off. I don't understand that, but that's why they have two people to sign these things. But anyway, it's hard for me to start somewhere because I don't think the court really looked at the facts that were presented in our responsive papers. Dr. Verk's affidavit, a lengthy responding submission of the summary judgment motion. None of these facts are mentioned in the decision. So we think there's plenty of factual evidence in the record. There is one curious tack that I think Kaleida took, saying, well, maybe we were negligent, maybe just we made some mistakes here, but that's not enough. Well, on this record, and given we've already had an independent fact finder find bad faith and a failure to investigate, and the evidence shows that the MEC for Kaleida wanted there to be an investigation, but no investigation was done, which led to the vacatur of the suspension by Judge Franzik. Those facts are, you don't see too many cases with those facts. So from that record, a jury could reasonably find that there was malice on both the common law and the statutory defenses. So unless there's further questions, I think really that's it. I mean, there was a case we cited. It's a constitutional case, a Supreme Court case, Hart-Hanks, about failure to investigate. And I think one of the points we made, if you don't follow standards, that alone is not enough, but it's some circumstantial evidence to show that there's bad faith. And that's what we've got in this case. We've got plenty of evidence to show that. And we really just think the court, I don't know, just didn't really look at the facts. So for some questions.
Thank you.
Okay. Thank you.
Good morning. May it please the court. Thomas Clokia for Kaleida Health. It seems the focus of the argument is on malice. And counsel mentioned the underlying decision by the judge to annul the suspension. And I just don't think it's that important. I think I would analogize this to ordinary negligence versus punitive damages. It's not a small step. It's a giant leap to go from ordinary negligence to malice. And there was an investigation here. And it was the same investigation that occurs during all these patient incidents. A chief of service reports to the CMO and or the president of the staff, and if there's serious concerns, they issue a precautionary suspension, not a summary suspension. And that's what happened here. In the testimony of Dr. Porosky, well, she had no reason to question any of this. Dr. Gibbons' affidavit, he had no reason to question the witnesses. He also spoke to Dr. Leonardo. And while the MEC may have recommended a further investigation, we'll concede on the underlying Article 78, the suspension was annulled. But even before we got to litigation, Kaleida offered, here's the records. We're offering you your fair hearing, which is what normally happens in this process. Why would they do all that if there was this grand scheme to get rid of the doctor? And I think it's important about what the fact finder in the arbitration, which was about the employer, the group, which Kaleida was not a part of, makes all these findings about Dr. Grandy and what he did in the group. But what the finder in the arbitration specifically did not find was Dr. Porosky was aware of any of this malice, Dr. Gibbons was aware of any of this malice, Ms. Saunders, who had the affidavit from counsel's office, never aware of any of this malice. So there's this attempt to say, well, in this arbitration involving the practice group, the group wanted to get rid of him, Grandy was the big one behind it, et cetera. Let's just impute this onto the institution of Kaleida. And I don't think that's how this works. You need to show the institution or those truly making the decision. Yes, Grandy provided the information, but they still independently evaluated it. I mean, what you don't hear a lot about is what actually happened to this patient. He died on the table, and the other providers are making comments as part of the preliminary investigation. Again, there was an investigation done. There was no investigation. That the other providers were very, very concerned about treatment choices.
I don't mean to interrupt you, go back to your thought, but do I have the record right that, I think it was Dr. Gibbons, maybe it was Dr. Prosky, I forget, they did speak to other people who were involved in the care, correct?
Dr. Gibbons spoke to Dr. Leonardo, one of the surgeons.
And so it wasn't just based on Dr. Grandy, albeit he's chief of service, so that gets you a long way, I suppose. But so really, what we really need to look at, and again, get back to your point if you need to, is whether or not there's a question of fact on malice based on the actions of your client, not Dr. Grandy.
That's exactly the point.
That's what we gotta look
And I think when you sort of take a step back, this stuff happens all the time. And I don't mean incidents in the hospital, but these investigations, chief of service, they're in charge.
Okay,
They
we
provide
understand
things.
that.
I know we have this letter from 10 years earlier, they mentioned potential,
We
but
understand
it's
about
just, to me, it's a giant leap of faith. Thank you.
193, Kavanaugh versus Consumers Beverages, Inc. Oh, and I'm sorry, thank you. Justice Kane is recused on this matter. Thank you, Justice Carr.
Good morning, Your Honors. May it please the Court. Kevin Lolonic on behalf of the petitioners Matthew James and Helen Kavanaugh. I'd like to focus on two major points, the first of which is standing. Special term dismissed the petition as against Matthew and James on the basis that they lacked standing. In so doing, special term relied on Section 11 of the share purchase agreement, which provides that in the event that a shareholder employee is terminated for any reason, voluntarily or involuntarily, that shareholder has to turn in his or her voting shares to be redeemed for non-voting shares. From that language, the court said, well, that's an automatic conversion. As soon as Matt and Jim were fired, those shares went instantly from voting shares to non-voting shares, so they didn't have their 20% voting interest to sustain a petition under BCL Section 1104A. That provision, there is no automatic conversion. There has to be an act of changing the shares from voting shares to non-voting shares on a motion to dismiss. That was Mr. Neil Kavanaugh's burden to prove, to conclusively refute standing with documentary evidence, such as the non-voting shares that were reissued to Matthew and James. They didn't do that. Or a corporate ledger that shows that those shares were, the voting shares were rescinded and the non-voting shares were reissued. Now, Mr. Neil Kavanaugh has argued, well, that's kind of crazy because Matt and Jim had their had the voting shares in their possession. But that ignores the reality of corporate governance. The corporate records, the shares, are kept by the corporation.
We'll look at all that. Thank you.
With respect, I have two more arguments on standing. The second argument is that in opposition to the motion to dismiss, we introduced evidence that calls into question whether Section 11 was even operated in operation. Back in 1993, when the family patriarch, the father was alive, Larry Sr., he was the majority voting shareholder then. He was the president of Consumers. He issued a questionnaire to all of his children, who were the shareholders of Consumers, and he said, what kind of conditions, preconditions, qualifications do we want to have for permanent, open quotes, permanent career, close quotes, status for employment at Consumers? And Neil, tellingly in his response, he says, I think the cat's out of the bag there. The die has already been cast, meaning people already have their expectations of permanent employment at Consumers, notwithstanding Section 11 of the SPA, which predated that questionnaire. At minimum, that raises an issue of fact as to whether the parties regarded Section 11 as being operative at any point in time after 1993. On that basis, we think that special term erred in dismissing on the lack of standing. The final argument for why special term erred in dismissing the petition for lack of standing is if the firings were oppressive, which we maintain they were, and we've submitted affidavits in opposition to the motion to dismiss, and then the petition details oppressive acts, acts of looting, acts of breach of fiduciary duty, all of that is credited on a motion to dismiss. It's accepted as true. Those raise inferences that the firings were retaliatory, they were motivated by oppressive animus, and if that's the case, and that has to be accepted as true, then everything that falls therefrom is called into doubt. It's in the reply paper, we called it the fruit of the poisonous tree. But Neil's
How do you get beyond the adequate remedy being beyond dissolution, and dissolution being disfavored?
Well, Judge, the adequate remedy requires a hearing. It's determined based on a totality of the circumstances. That's what the Court of Appeals said in Kemp versus Beatley. So the trial court has to take into consideration the severity of the allegations of oppression, and if they determine that those are merited, then the court fashions the remedy based on that. You don't have to establish your entitlement to a dissolution at the pleading stage.
Now, speaking of a remedy, we had an email from one of the counselors here that you were working hard in mediation to resolve this case with the trial, and it's a new trial, Judge. That's not correct?
It is correct that there are currently settlement talks ongoing. That the judge that decided the motion to dismiss is not currently the judge on the case. Those are both correct facts. I don't believe that the settlement should impact the decision on the merits of the case. It appears that there's a couple of things that are happening that might derail those settlement talks.
Well, what happens here could derail those settlement talks too.
That's very true.
As long as you're aware of that.
Unless there are any other questions, we will rest on our papers.
Thank you.
Thank you.
Good morning, Your Honor. Dennis Garvey. I represent Mary Ellen Kavanaugh. She's a respondent. As I said in my papers, I agree with Mr. Lalanik's argument. Even though she was not a petitioner, she was brought into this as a respondent, and I just wanted to say that we agree with it. I'll stand on my papers. If there were any questions, I would certainly answer them, but otherwise, I don't have anything else to add that Mr. Lalanik didn't.
But if the standing argument were to proceed, would your client have standing?
My client is a respondent. She didn't bring the petition. So we're here because she's a respondent, Your Honor. And no, she wouldn't. She didn't have voting shares, put it that way.
She didn't have voting shares, okay.
Thank you.
Thank you.
Counselor, do you agree with the position that there's not an automatic conversion to non-voting shares?
Your Honor, the agreement provides in its preamble, so the share purchase agreement in its preamble says that voting rights belong solely to those shareholders who are employed by the company. So I think that's the operative section of the share purchase agreement. It's on the very first page of the share purchase agreement. Later in the agreement, it indicates a procedure that is supposed to happen when a shareholder who is an employee is terminated for any reason, for cause or without cause. So first of all, that provision, I think, counters the suggestion by petitioners that they had an expectation they would be employed forever. The very agreement that gave them these shares indicates that they can be fired with or without cause. But in that procedure, to get back to your question, Judge, in that procedure, Article 11 of the share purchase agreement, it provides that it is the obligation of the employee who's been terminated to turn in their shares. They did not do that. It's not the obligation of the corporation to go out and chase them down. It's the obligation of the employees. And that is very similar to this court's decision in the Hessek case, which we cited in our brief. In that case, there was an obligation for a shareholder who dies, that the shares transfer to the surviving spouse. The spouse is obligated to sell them to the corporation. In that case, in Hessek, the spouse refused to sell them, turned around and brought an 1104 dissolution action, 1104A dissolution action, claiming to have standing because she still possessed these shares. And this court said, no, you can't, by your own failure to abide by the agreement, create standing when you don't have any. The shares didn't belong to her under the agreement. The shares don't belong, the voting rights don't belong to these petitioners under the share purchase agreement, because they only had voting rights while they were employed. And it's undisputed that they were terminated before they brought the petition. In fact, it's an allegation of the petition. The termination letters are attached to the petition, and they allege in the petition that they were terminated from employment. So they clearly had no standing. If I could take a step back from the standing issue, the broader issue, which you identified, Justice Greenwood, that the court really decided on is that there is other adequate remedies here. Dissolution is a very drastic remedy, and it is not to be used as simply another arrow in the quiver of people who have business disputes. The court has called this a judicial death penalty for a corporation, and therefore there are a series, both statutory or common law, there are a series of requirements the court must find before it proceeds with a dissolution action. It must find that it's the last resort, it must find that it's necessary, okay, and it must find that it is the only feasible means to protect the minority shareholders. And in this case, the trial court, in its discretion, found that the proceedings to date, the pleadings, the 5 other actions that were pending between the same petitioners and my client, Neil Kavanaugh, or the company, those 5 other actions all sought the same relief based on the same claims.
Mr. Doyle, pardon me, remind me, I think I know, what are the other remedies that are available?
Yeah.
There's a whole series of cases, so forgive me for forgetting, but
Sure.
what are the other remedies is my question.
So in this case, the 5 other actions all brought claims for breach of fiduciary duty, conversion, fraud, violation of the business corporation law, violation of the New York State employment law. Those are the claims. The remedies that are sought are monetary damages, disgorgement of allegedly improper gains, removal of Mr. Kavanaugh as the president and as a director under the business corporation law, and accounting. So all of the very same remedies that they are seeking here, short of dissolution. And what the trial court found was those remedies are more than sufficient to remedy the ills, the bad conduct, the claims of the petitioners here. We don't have to destroy a very successful Western New York company that employs over 270 people, that the undisputed evidence submitted on this motion is very well run, well regulated, and no improprieties found by an independent auditor chosen by all of the petitioners in another action.
It's almost like a be careful what you wish for argument.
Well, it should be, Your Honor, really. But that's why, under the statutory and common law provisions for dissolution, there are such high hurdles before we can simply allow this to happen. Or else every business dispute that you're going to see where someone's unhappy about something is going to be a dissolution action as well. Thank you very much, Your Honor.
Thank you.
Court stands in recess.